Hey, good people. My listeners, hello, across the planet. Welcome back to Legacy Pulse podcast with me, Pepe Onjima. Legacy Pulse is powered by Kuchu Times Media Group. I invite you again today to continue the conversation on strategic litigation, its roots, status, and impact on the lives and existence of queer Ugandans or the LGBTQ community in Uganda. In the last episode, I spoke about the roots of strategic litigation and the Victor and Oyo case being significant for that. Today, I want to go to the cases that I hadn't talked about. We're continuing the legacy of strategic litigation. We had stopped at 2014, but we had jumped a little bit into 2016. And in 2016, we had the Lokodo case, which is seeking remedies or reaffirmation of the queer community having a right to assemble, express, and associate. This was following Lokodo's barging and raid on a capacity development meeting held in Entebbe. Secondly, we filed a lawsuit against the Uganda Registration Bureau for refusing to register Sexual Minorities Uganda on allegations that the name was unfit and that the objectives of the organization would consequently result into promotion of homosexuality. Thirdly, the Sean Mugisha and others versus the Attorney General and DPC of Kabalagala Police Station. These are the three significant cases of strategic litigation in 2016. What have been the outcomes of these three cases? In the Lokodo case, we appealed. I'm one of the plaintiffs. In that case, it's Kasha Nabagesera and others versus Attorney General and Father Simon Lokodo. Since then, Father Simon Lokodo has faced his demise. The Court of Appeal upheld the decision of the lower courts in denying the right to associate based on people's sexual orientation and gender identity and expression. Today, this month, this year, we received another negative judgment in the appeal and underway discussions to take it further. And what does that mean? It means that all these remedies have been exhausted and we are going to the highest court of the land, and that's the Supreme Court. That is yet to be decided by the parties involved. The Sean Mugisha case has no ruling yet, but we are pushing and hoping for a better ruling. But justice delayed is justice denied. And in the SMAG registration case, the first court ruled in favor of the Uganda Registrations Bureau. We went to the Court of Appeal, and Court of Appeal last year in 2025 upheld the decision by the lower court that SMAGs or Sexual Minorities Uganda should not be registered because the name is undesirable and the organization will eventually promote homosexuality if granted legal status. In that case, the case was elevated to the Supreme Court. The appeal currently sits at the Supreme Court. There was a hearing last year in 2025 to determine the merits of the case, and the bench at the Supreme Court of 5 judges accepted our plea to stay the case and Anti-Homosexuality 2023 appeal at the Supreme Court is heard. And it's clear why that was done. Maybe it's not, but the Anti-Homosexuality Act 2023 prohibits what they deem as promotion of homosexuality, which means that if we got a loss, or if the judges decided, if we had a hearing then, and the judges decided that SMAG still cannot register, or if it's a victory, it still wouldn't be a victory because the Anti-Homosexuality Act would still come in handy to prohibit further association. So the SMAG registration case appeal at the Supreme Court was stayed until after the Anti-Homosexuality Act has been decided upon. In 2020, we had the cause of 20, and the cause of 20 is a case where community members of the organization, the Children of the Sun Foundation, COSF, their shelter in Chengera was raided by a local council chairperson who came along with the police and humiliated queer youth who were at this shelter and continued to be tortured while in remand at Chitalia Minimax prison. When the shelter was raided and they were taken to Chitalia, the 20 members were denied access to legal representation, and they were tortured before and while they were in custody. So this case was filed against the Attorney General, the local council chairperson, and the prison officers involved, challenging their actions. And this was a victory, as the court pronounced itself, that indeed the cause of 20 were tortured and denied access to their lawyers, and the court ordered remedies to be paid to the victims of the violations of these authorities. With that, I would like to transition into current Anti-Homosexuality Act 2023, which was introduced in 2023 by the Parliament with an overwhelming majority, amidst intimidation, name-calling, and you could say a touch of hooliganism. However, the President signed it into law, and we had come together to create a version of the civil society coalition that took the mantra and was the central coordinating point between 2009 and 2014. And this new coalition that was brought together and is led by queer folks, called Convening for Equality. Convening for Equality did literally the same thing. Invited our friends in SRHR, human rights work, democracy, just came together and organized and formed the CFE. So under the CFE, various petitions had actually come up. This law really created a moment of character development for everyone who was involved. We saw some civil society organizations fighting to revive the civil society coalition on human rights and constitutional law. Whereas the LGBT community said, we have enough capacity to lead our own struggle. We thank you for what you did between 2009 and 2014, but now we have the capacity to lead. Can you work with us? This was not an easy thing. Groups were divided. There were other parallel or alternative spaces that were created, some really pertinent, because representation is very important and it's key. But the Convening for Equality, CFE, deliberated on the many appeals against the Anti-Homosexuality Act. In the beginning it was not successful, but the court ordered that all the different petitions be consolidated into one. So this appeal basically brought different petitioners. There's petition 14, petition 15, petition 16, and 85 of 2023, all challenging the constitutionality of the Anti-Homosexuality Act 2023 and the manner in which it was passed. This particular law introduced offenses of homosexuality, aggravated homosexuality. Yes, in the 2014 Anti-Homosexuality Act, there was aggravated homosexuality and there was death penalty. And the death penalty was dropped in 2014, but then it's brought into AHA 2023, further prohibiting the renting of premises to persons or groups for purposes of quote-unquote homosexuality, and mandated the public, including health workers, to report any person they suspected of homosexuality. And this act was being challenged on 14 major grounds, including the fact that it infringed upon the human rights of supposed LGBTIQ persons in Uganda. Also that it was passed without impactful consultation of the public, that the conduct of the speaker in passing the law was inconsistent with particular articles of the Constitution, among other grounds. The court in its verdict upheld the Anti-Homosexuality Act, stating that it was not unconstitutional in its passing and it did not violate the various human rights of LGBTQ persons as had been argued. However, in their decision, they nullified some of the provisions of the Act, including the provision that aggravated homosexuality on the fact that a party contracted a terminal illness, including HIV, the provision on denial of premises as it denied people, LGBTQ persons, adequate housing and the duty to report acts of homosexuality. Despite the few nullifications, the law was largely upheld. The death penalty stayed in there, and it has continued to wreak havoc in the lives of LGBTQ persons in Uganda. Even as I speak right now, a young man allegedly having sex. This was going on social media. Past videos of maybe 2018, maybe 2022 have been circulating, particularly on TikTok. And there's a TikToker who was in one of the videos, and there's some young people who were in the video and on tricking the young man. He was arrested, tricking him to go and apologize to a particular minister to forgive his sins. This young man is in prison on allegations that are yet to be proven. As I talk, there are two young lesbians, 21 and 22, in Arua City, who are in remand because of political impunity and allegations of practicing lesbianism, and their case is yet to be heard. They were denied bail, and the next hearing will be on April 8th. The havoc continues because it has emboldened, it has empowered, it has given police and homophobes and transphobes a license to violate private property, privacy, dignity through mob attacks, conversion therapies, extortion of different things, extortion of sex, extortion of money, extortion of property, gadgets, and so on. And we've been seeing an increase of the havoc that the Anti-Homosexuality Act is wreaking. That said, various cases have been reported in the course of, during the passing of the Anti-Homosexuality Act. Right now, during litigation, LGBTQ persons continue to face violations. The first male person that was arrested when this law had just passed was Michael Polot in Soroti City, and his case was only recently dismissed from the court. 2 years of a young man's life gone to waste, severe mental health problems, having to face this term in prison, and the back and forth trying to seek justice, and the persistent denial of dignity. However, we celebrate that as a win, which is one of its kind, because others continue to go to prison. There is a picture that seems to be painted that the law, after nullifying parts of it, is actually shelved. No, it's not. Politicians keep reminding the public all the time how the law is there, how homosexuality is wrong and people must look out for it. And we've seen arbitrary arrests happening. While at Supreme Court, we've been anticipating and waiting for a date to be set for the hearing of the case. And the decision of the court in this matter, the appeal that is at the Supreme Court, is set to be heard on 31st March 2026. What does 31st March 2026 mean to the queer person in Uganda? It is a significant date. It's not just for queer Ugandans, it's for Uganda. This has been one of the laws that has had a lot of criticism for the legislators, but also for the community. It has had a lot of backlash. We saw solidarity to a certain extent from the World Bank by holding funding to the country. And for the first time, LGBTQ Ugandans sat at a table, or rather sat at a room, and had engagements with the World Bank. The negotiations, people in the room were LGBTIQ persons from across the country, including a rural LGBTI person in the room, different persons from ministries, either permanent secretaries or undersecretaries and so on, coming to present at a meeting held by the World Bank in Kampala for several days. And the negotiations were in Kampala, they were in Washington, D.C., and basically getting different stakeholders to urge our courts to drop this law because it's unconstitutional and continues to endanger a marginalized group that has no substantial havoc or damage caused in the society of Uganda. This law, its roots, just as the first one, is driven by American conservative evangelicals. Funding, technical support, and political support came in handy to bring this law into force. And the anti-LGBTQ movement has since grown. I mentioned Uganda being ground zero, or being the laboratory where these discriminatory laws based on sexual orientation and gender identity, particularly targeting LGBTQ persons, is usually manufactured and then spread like a common cold or a sneeze across the continent and across the world. Most of them emphasize conversion therapy, the promotion of rehabilitation from homosexuality. It's so laughable that how do you think locking someone up is actually going to change their natural sexual orientation? The hearing for this case is on 31st March 2026. I want to also touch on the Legal Brain Trust versus Attorney General of Uganda, where Legal Brain Trust filed a reference to the East African Court of Justice for Sexual Minorities Uganda, SMAG, in 2022. The reference filed before the EACJ is to oppose the shutdown of SMAG by the NGO Bureau, stating that it operates illegally following the decline by Uganda Registrations Bureau to reserve a name for and register Sexual Minorities Uganda as a corporate body. LBT, or Legal Brain Trust, argues that the decision to shut down operations by the NGO Bureau was unlawful and infringed on the principles of good governance enshrined in Article 6D and 7.2 of the Treaty of the Establishment of the East African Community. The case is still before the court, and we keep watching the space for this. And the hope really has been that eventually homosexuality can be decriminalized in this country. In all these cases, won or lost, I've examined the precedent that litigating the rights and matters of LGBTQ persons in Uganda has shown so far. And it is inevitable to note that despite the existence of some wins, litigation has largely proven to be a disappointment in trying to achieve dignity and human rights for LGBTQ persons. So back to our original question, and the question that stands is that we are reflecting and diving into interrogating our freedom. What does liberation look like for you, a queer person, for me, as a queer person, as a leader in the community, as a person who began LGBTQ activism when I was 15? Over 3 decades of doing this work, do I see my freedom in the courts of law? Do you also see your freedom in the streets or in the justice system? Where do you place yourself in strategic litigation today? Where did you place yourself in strategic litigation before today? A lot of people probably listening today were either in primary school, not born, or were not yet out of formal education, and some may not have gone to formal education. The courts, especially in the last 5 years or so, have used their power to reiterate and reinforce criminality of the lives of LGBTIQ persons. They continue to exclude LGBTQ Ugandans from certain rights that every person is entitled to enjoy as a human being, inherently enjoy as a human being living in the borders of Uganda. Those rights are enshrined in the Ugandan or the Constitution of the Republic of Uganda. Where the courts have whatever looks like a win, where the courts recognize rights of LGBTQ persons, especially on privacy and dignity, they have consistently either attached limitations to those decisions or ignored to explicitly pronounce themselves on the same. Of course, this has been influenced by a number of factors, including the bias and inequality of judicial officers and the judicial system as a whole, together with the weakness of those who seek the interventions of these courts on behalf of LGBTQ persons. This therefore poses a question of whether litigation is still an avenue to be explored in achieving dignity, liberation for the LGBTIQ persons in Uganda. And if so, how can it evolve to actually being gainful or protecting the LGBT communities of Uganda. When we talk gaps, when we talk weaknesses of the interventions, several community organizings or convenings have happened. And obviously the question of strategic litigation, I think in the last 5 years, has caused some serious divide in how we organize the LGBTQ movement in Uganda. Over 50 queer organizations, majority doing HIV and health work, few doing advocacy work, and one of those being the network Sexual Minorities Uganda, which is an LGBTQ network that really focuses on advocacy. Other organizations as well, community-based organizations, informal organizations. There's generally been disappointment and the question of why are we even going to court? The issue of visibility still remains paramount. Protection of that visibility is important. I want to focus a little bit from different conversations off air that and other smaller fireplaces have been about the teams that the community allow to seek interventions of the courts on the community's behalf. There are different allegations that have come up based on people's experiences of the very people on legal teams being homophobic, dismissive, misogynistic, transphobic, and how they shouldn't be their representative. But how do these teams come together? Various CSOs work with the community, and different community members associate with different CSOs. There are, for instance, in the AHA 2023 appeal, you see that there's petition 14, 15, 16, and 85. Why wasn't it one petition from the beginning? The divides always exist in organizing. In fact, if you are in organizing and you're not challenged, if you're in organizing and you don't at some point hit rock bottom and rise, then you aren't truly doing what needs to be done, because you need, as an organizer, there must be a point where you are uncomfortable to get to comfortable. And these are the conversations now going on in the corridors of how can our lawyers tell us that they don't have hope? We are holding on. This is life and death for us. How do we sit in a room and face our legal team and they say they don't see a positive outcome? Like hell, what is that? I received various phone calls, basically challenging phone calls. One of the calls, the meetings where community members had been, a person was basically holding me accountable, telling me, after all these years, why would I and the rest of the other leaders accept for such meetings to do that to them? I have no control, of course, as a sole activist, also living my life while looking over my shoulder every other day, to control actions, budgets, and programs of different organizations that serve the community. I asked the person, are these questions you asked in the room? They did not ask the question in the room. But as a leader, it got me thinking that, what are we missing? Are we distributing community power? Of course, in this capitalist and political animal of the world, we only strive to have equality. We should be striving to achieve equity rather than equality, because various people are comfortable in their comfort zones. I remember an attempt to organize queer legal teams, because the thing has been that, yes, a cishet person or lawyer might understand non-discrimination, but they will truly never know what a queer person goes through. Questions like, are queer people who are lawyers with practicing certificates allowed at the table to discuss? Are they largely seen as queer people rather than lawyers? And in many cases, maybe. What has been their contribution? Is there self-stigma among queer persons who are professional lawyers? What causes it? Is it a real thing? Is it not? Are they even wanted in rooms where their lives are being discussed about and they have the professional skill and knowledge and they are not let close to the table? The truth is, some of these spaces have become tokenizing, or continue to be tokenizing, where they will bring in an LGBTQ person, mainly either for testimony giving and professional side not being appreciated or recognized at all, or just to sit there and say nothing, or come there to further traumatize themselves by giving testimonies of violations that they have faced. So many questions, very little answers. At the start of this conversation, I talked about the incremental approach of strategic litigation as one of the things to do. And one of the things that breaks my heart is the cases of forced anal examination, outright bodily harm, torture. Why haven't these cases up to now been brought to light? Why has that been just kept at the Uganda Human Rights Commission? And why isn't it being followed up? Is there political will? The different actors who seek court pronouncement on LGBTQ cases, is there a willingness for this to actually go away? Or it has become a cash cow for mainstream stakeholders to whom we seem to have given or surrendered our liberation? Are our legal teams doing right by us? Are our partner organizations doing right by us? Are we as the community doing right by ourselves? You sometimes sit in a room where LGBTQ people are seated in a room, and people we have entrusted to walk the journey with us for our freedom, while they speak, we sit in the room just receiving all this information with very little interrogation. And sometimes when interrogate, we really do not express ourselves to make the point. But I think even that in itself is making a point. To say that the space or the spaces are not providing adequate emotional and mental protection for one to be able to express themselves fully to what they want because of legal jargons thrown at the community members. I remember an incident when mobilizing and filing the petition against the Anti-Homosexuality Act 2023, where one of the organizations mobilized paralegals and community members from across the country to come and challenge one of the petitions and the leaders, to challenge the leaders of convening for equality, so as to say that CFE has no jurisdiction or has no mandate to go to court, but this organization's coordination should be the one that is considered. And it was so embarrassing and so disappointing to hear from some recordings that the community itself was bashing its own leaders within that room who were trying to make them understand what CFE does and what CFE is doing to carry space and hold space for the community to be able to have much more say in the litigation process that is happening. To a large extent, the community has forgotten its agency. The community has been deliberately divided to keep relevance on mainstream organizations rather than LGBTQ organizations that are centering, championing, or eradicating the conservative, homophobic, transphobic mindset towards the community itself. We were joking about the financial cost of litigation vis-a-vis the financial cost of attitude change through social, economic, political avenues. Back then, when we were discussing incremental process, we were looking at go to the magistrate court, win a case, take that case of torture, take that case where someone is extorting money from you, yet they've robbed your house, robbed you, beaten you. Take that case. Let our lawyers, queer or not, go to the magistrate case and argue these cases. You've been thrown out of the house, sue your landlord. We've been urging people that when you get to housing, and someone might say that I'm speaking from a point of privilege. No, I have been, I think it was only recently, less than a decade, that I have been able to put my name to a rental space. And I did that as a radical act to reclaim my right to housing. For all the years that I have been renting, the rent has never been in my name. As a safety measure, so that I am not, as a trans person, I'm not picked out and thrown out and the landlord enjoys my money while I'm homeless. It was one of the strategies that I had to have to make sure that I have a roof over my head. So I know what it's like to be kicked out of a house. I know what it's like for a landlord almost putting their signature, then they realize that it's you. I have experienced majority of the things that I stand up to today. Bravely, it has taken a toll on me in the way that, you constantly have to remember that this is a life and death issue for you. So one of my lessons really with strategic litigation is that I've felt and shared this thought and feeling that it is work for some of our partners because it's not urgent enough, because life has not particularly been threatened. So the urgency to push radically for these cases to move in our favor is low. We generally have become or are still a reactionary movement. And what I mean is that different organizations, of course, are doing the work that they are doing, which is amazing. Especially I want to give big ups to rural queer organizations across the country that are trying to do the most. Yes, they might use, health or HIV, because that is also how they need to keep safe and be able to secure protection and access to different services for their communities. Rural communities, and this is not to say rural communities versus urban or peri-urban or what. No. It is just that there's little acknowledgement that goes to community-based organizations for the environment in which they work and still stay alive and stay sane. Urban, of course, has its mixture, and a lot of decisions are made at urban level. There have been efforts to consolidate across the country evidence, programs and projects, resources, community resources to come to the taste of freedom and liberation. Many rural organizations, rural people, even the city actually, do not think litigation is the way to go after the several losses and divisions organizing around litigation has caused. So has strategic litigation caused more harm than good? Is it an avenue we want to continue exploring for us to have our liberation? Those are not questions for me to answer. We can have conversations about it. There are different generations of queer people. I'm one of those you could maybe say is in first generation, but maybe I'm not of first generation. Maybe first generation is the generation of Kabaka Mwanga and others. But maybe the generation of activism, I come from that one. And there are different generations now, doing things differently, and which is amazing. Litigation might still remain a relevant piece for us to continue exploring how we achieve our freedom and our liberation. It shouldn't be the only way. Therefore, how do we resource in a way that is not taking from the community and is not subjecting the community in this cycle of poverty, of begging to be seen, of begging for access? One of the things that I really want to conclude with is a call to queer people who are studying to be professionals, queer people who are already graduated and have practicing licenses. You don't have to be afraid. You are a professional. You are a lawyer. You are an attorney. You can do it. We can generate resources from amongst us of your skill, of the little pockets of money. We can do it. One of my dreams for liberation is to see a full team. You do not have to wear the badge of your sexuality, but as long as behind the scenes we know who you are, we recognize and hold you to honor when you stand in court to defend your community fearlessly, ferociously, for that justice that you want. the justice that we want. I cannot wait to see a team like that. Integration, intersectionality is a conversation probably for another podcast, but in my experience, there's been 100%. I've said it. It's one of the current cliche terms. It's really been LGBTIQ persons who have been pushing to be in spaces without any monetary gain, to be in a space to say, when media is being violated, I'm going to go for a march for their dignity and their freedom. When women are marching for their dignity, queer women, queer men, trans women, gender non-conforming persons, or non-binary people come to those marches to say a cis woman who is being oppressed is my sister, is my mother, is my person, I'm going to march. How many times have we held pride marches in Entebbe? And we've seen cis-het people, cis-heterosexual people coming to those marches to support us, to glorify, to honor us. It's a handful. In most cases, the intersectionality is practiced in tokenism, where a queer person will be invited to tick a box that, oh yeah, we had a trans facilitator, yes, we had a lesbian rapporteur, or, testimony giver. That needs to stop. I also want to urge the community to mwekubemu torch what is the worth of your existence. And I'm happy to have the privilege to be able to interrogate at the way I'm interrogating today. My blood, sweat, tears have been invested. My youth has been invested in this movement. And I'm also privileged to still be alive, to carry the memory, to share the memory of the things that I've experienced individually and collectively. How hungry are we for our freedom? What are we willing to do to get our freedom? What does queer liberation look like to you? Thank you so much for listening to me, and we'll continue to carry this conversation of strategic litigation by the fireplace soon. See you soon. Stay safe. Let's hope for a victory at the Supreme Court. Aluta continua. I've been your host, Pepe Onjima, on the Legacy Pulse podcast, powered by Kuchu Times Media Group. Follow the conversation, join the conversation. Find us on our socials, across all platforms, Kuchu Times Media Group. Follow the hashtag Legacy Pulse with Pepe Onjima.